There is a judicial doctrine called the administrative stay. It appears in no statute you have ever read, and a single federal judge can use it to halt any executive order in the country within hours, with no hearing, no briefing, and no vote. It has operated this way since the 1970s. You were never told it existed. By the end of this, you will see government the way people inside it see it. Here is what it actually is. When a new executive action takes effect, an agency rule, a presidential order, someone files a legal challenge. Before that challenge is fully briefed, before both sides have argued, before any hearing is scheduled, a judge can issue an administrative stay. Not a preliminary injunction which has legal standards you have to meet. Not a temporary restraining order which requires a showing of imminent harm. An administrative stay, a unilateral pause, issued in hours, sometimes less. The executive branch keeps moving. Then it stops, because one person said so. Here is how it was born. No Congress debated it. No president signed it into law. Federal courts derived it from a doctrine called inherent judicial authority, the idea that Article III courts possess powers not enumerated anywhere because they must possess them to function. The Administrative Procedure Act of 1946 gave courts authority under 5 U.S.C. Section 705 to postpone agency action pending judicial review. That provision is narrow, specific, bounded. Courts went further. By the early 1980s, judges in the D.C. Circuit were issuing administrative stays on their own motion, meaning without either party requesting one, simply to preserve the status quo while they decided whether to do something more formal. One court built on the reasoning of the prior court. The doctrine became infrastructure. No hearing produced it. No floor vote authorized it. The courts gave themselves this tool, and then they used it. Remember, no one voted for this. Now here is who controls it. Any federal district judge in the country. One judge, one district, nationwide effect. There is no geographic limit in the doctrine. There is no minimum threshold of legal merit required before a stay issues. The judge must only believe the matter requires closer examination. The standard is self-referential. Is a stay necessary to preserve the court's ability to hear the case? The judge decides whether the judge needs more time. The government has no automatic right to be heard before the stay lands. One person makes this call alone. And here is what that power looks like on the ground. January 2017. The first travel ban executive order was signed. Within 48 hours, a federal judge in Seattle issued an administrative stay blocking it, not just in Seattle, nationwide. Customs agents at international airports across the country received mid-shift instructions. Passengers already in the air, carrying valid visas, were affected before their planes touched down. No second judge reviewed the stay before it took effect. No Congress weighed in. The hearing on the merits was weeks away. One person in a federal courthouse in Washington state halted the immigration enforcement apparatus of the United States government in hours, using a power that does not appear in any statute Congress ever passed. Ordinary people, visa holders, airlines, border agents, had their immediate reality changed by a legal instrument that has no democratic origin. It issued. It took effect. That is all. And here is the part that should actually worry you. It is completely legal. Because the administrative stay derives from Article III itself, Congress cannot simply eliminate it. Any statute attempting to strip courts of inherent authority runs directly into the separation of powers. The judiciary's independence, the very principle that legitimizes everything else courts do, is the same mechanism that makes the stay untouchable from outside. The only institution that could abolish the administrative stay is the Supreme Court. The Supreme Court invented it. They have every structural incentive to preserve a tool that keeps the executive branch answerable to judicial oversight. The doctrine is self-protecting. The lock is in the foundation. You cannot reach it from where you stand. This is the architecture beneath every institution you will examine if you look long enough. The tools that hold the most power are never the ones that went through a vote. They are the ones that grew in the space between written law and necessary function, where courts and agencies quietly constructed authority because no one told them they could not. Administrative stays, prosecutorial discretion, agency guidance documents, signing statements, named mechanisms operating with no public mandate, enforced by people never elected to enforce them, shaping your life in ways you were never informed about. Each one is a variation on the same structure, power that became permanent before anyone thought to prohibit it. The question with no clean answer: if the most consequential legal tools in this country derive not from law but from tradition, from the inherent authority that institutions claim for themselves, then who actually governs? Not in the textbook, not in the constitutional diagram, in the hours between when an order is signed and when a judge decides whether it stands. In that window. In every window like it, who is in charge? And is there any mechanism anywhere that can answer that question from outside the system that created it? You were never supposed to ask.